want to take Ellie's invitation to go back to sort of the tort system before we had bankruptcies, because in those days, plaintiffs, because of common law or state law prohibitions on claim splitting, would file one case against everybody against whom they thought they had a case. And because of concerns about statute of limitations, they wouldn't withhold anything. The system that Elihu and his clients have created over the last 18 to 20 years.
Court approved.
I will give him that small concession. Has created a sort of strange, sort of dual universe where we've taken, and I'm really disappointed that Elihu doesn't have Joe Rice's great fruit slides, because I think they add some spice to this discussion. But what really is going on here is the plaintiffs say, well, we want to take some collection of assets from the failed defendants. And to keep the Illinois connection alive, I counted around $8 billion in the trust coming online. We have, the estimates are $35, $40 billion. It's a lot of money, however you slice it. In the words of the former Illinois Senator Everett Dirksen, sooner or later you're talking real money here. But what we object to is any effort to take that set of assets and this information about claims out of the tort system and to leave us without access. Now, Elihu and others in his position at these presentations have said, well, what you want us to do is you want the plaintiffs to do your work. And at some elemental level, that's correct, because you have to keep in mind the reality of how asbestos claims are litigated. Very few people who see Aaron Brockovich on TV and call a lawyer or go on the internet looking in sort of faint hope for medical advice and type in mesothelioma know against whom they have claims. If it's a premises claim, they may have an idea. I worked at a refinery. My employer probably has some responsibility. But one of the values the plaintiff's bar provides to claimants is they help them navigate against whom they have claims. And that's a process that takes some time and attention if it's done right. What we want to have happen is at that inception of the case, the plaintiff should do a full and complete job of isolating against which defendants, viable and otherwise, these plaintiffs may have claims, and make that information available. That is relevant to us. Now, Elihu is also right that the world has changed over the last 20-some years in terms of the rules of the road. We used to exist largely in a world of joint and several liability. Some of this was less relevant, but increasingly I think there are only 10 or 12 states that are pure joint and several liability states anymore, and most of them don't matter much for asbestos litigation. It does matter because we can get companies, other entities on verdict forms, we can get allocations, we can certainly argue supervening, intervening cause. So all this, particularly the exposure evidence, is critical. And as the litigation has changed over time, since it has become the norm that every insulator with mesothelioma has also done a recreational remodeling of a room in his or her house and used joint compound in the mid-70s, while at the same time doing backyard mechanic work on their cars so they have friction product exposures, we are entitled to know the full panoply of claims those people think they have. And that's all we're arguing for here is really fundamental fairness. The plaintiffs and their counsel control the metes and bounds of litigation. Tell us at the outset, level the playing field in that respect. We don't think it is fair, appropriate, or for that matter legal for the plaintiffs to be able to partition $35 billion in assets and hold it outside the system and have that money, those resources, and the evidence that supports those claims, and I put that in quotes, to be outside the tort system where we're forced to litigate.